Good morning, everyone. Welcome to the October session of the Burr Morning Show. Thanks for joining us on Halloween morning. We are going to be talking this morning about tricks, not treats. My name is Emily Mack. I'm a partner in the Nashville office, and Maja Hartzell is with me, and she is also in the Nashville office. And so what we're going to be discussing this morning are some of the common employment pitfalls to avoid. These are things we deal with day in and day out in advising clients on labor and employment matters. And we're going to try to put a little bit of a Halloween spin on the content because these are things that can obviously get your companies into compliance troubles, and we try to avoid those things. So we're just going to be hitting some of the common issues we see. If you have a question or a comment, drop it in the chat and we will try to get to it. This is again intended to be some free legal advice for you guys. So to the extent that we can answer any burning questions, we're happy to try to do so. And if not, shoot us an email after the session and we will try to get back to you on this. So we're going to dive right in here with pitfall number one, ghosts of misclassification. There are really two forms of misclassification. When we refer to misclassification, we're talking about two different things. And the way that this typically comes up is we see either non-exempt employees who are classified or misclassified rather as exempt employees. And it also comes up with independent contractor classification, workers who should technically be classified as employees who companies classify as independent contractors. And this, there's a lot of really let's talk first about employee misclassification, right? The most common issue I see here is employers will call me and say, we have an employee who is salaried. And they will use that term, and there is a misconception that if someone is paid a salary, that means that person is exempt from overtime. What we forget about, or can be forgotten about, is that there are two tests required to classify an employee as an exempt employee. The first is that employee has to meet the salary threshold in the state in which the work is being performed. Under the FLSA, that in states that adhere to the federal salary threshold, that is currently still at $35,568 annually. However, many states have enacted higher salary thresholds. So when you have remote employees, the state in which that employee is working is the state salary threshold that is going to apply to their work. And so you need to make sure that you are being compliant with the state in which they are working on meeting that salary threshold. The second component to classify someone as an exempt employee is that they meet a job duties test, and commonly referred to as white collar exemptions. Those are some of the most frequent ones that we see, but they, not necessarily every type of work will qualify for an exemption. And so when we're talking about the administrative exemption, which is a common one, that refers to an employee that has independent discretion, autonomy over matters of significance involving the business. So they need to be, managing a department. They need to be able to have control and autonomy over things like entering into contracts or what type of services, how to proceed, not simply performing administrative tasks. And so the name of that exemption is a little misleading because it's called the administrative exemption. By no means does it simply mean performing administrative work. In fact, that's one of the frequently misclassified positions that we see is someone who is considered to be an administrative professional. That does not mean that person would necessarily meet the criteria needed to be classified as exempt under the administrative exemption. Another common white collar exemption is the managerial or executive exemption, and that is going to apply to your managers, someone who has the authority to regularly supervise more than 2 employees and to be able to hire, fire, or their recommendations with respect to hiring or firing are given significant weight. So again, this is by no means exhaustive. Those are just some of the ones that we see, but more often than not, when there's a pitfall here, it's employers who overlook this or think that we can just pay someone on a salary basis, and that means that they're exempt from overtime, which is not the case. They have to meet both that salary threshold and the job duties test. One other note about that I see in Pitfall in terms of classification with respect to exempt employees is being paid on a salary basis is a term of art. It's a legal term of art, and it has a specific meaning. It means that the amount that they are paid can't go up or down if they generally perform any portion of work in a given week. So you can get into trouble and lose the exemption if you are docking pay or salary, except for certain specified situations. So be careful with that too. Generally speaking, that means the amount they get paid, doesn't change, even if they are absent for a partial day. That's a perfect example of a situation where you cannot dock pay for absences less than a full day. Independent contractors, I see this probably on a weekly basis. I'll get a call from a client who says, I need you to put together an independent contractor agreement. Keep in mind here, the default rule with respect to workers is going to be employee. That is from the Department of Labor, it is from the IRS. And so the company is the party with the burden of showing that a worker has been appropriately classified. And so if we are seeking to classify a worker as an independent contractor as opposed to an employee, the burden is on the company to show that they meet the criteria that are required in order to do that. Now, depending on what state, federal, what specific law we are talking about, there are multiple different tests that will establish is someone an employee, but all of them will involve similar factors, and control means paramount. But oftentimes when I hear, I think the misconception here for companies is that, well, I don't set their hours, so I'm not controlling them. That's not really what the right to control means. It might be one of the things that goes into determining, does the company have the right to exercise control over this worker? But these other factors, I think, are much more significant. And so what I mean by that is, the worker's preference, completely insignificant. That is something that I hear a lot, is that, well, the worker would like to be classified this way, or wanted to be classified this way, or we want the worker to be classified this way. And that is immaterial. If the work being performed is integral to your business, meaning that what they do day in and day out for you is something that is part and parcel to whatever the nature of the business is, I think it's going to be very, very difficult to properly legally classify that individual as an independent contractor. And so what I mean by that, or a good example or hypothetical I can give to kind of illustrate this point is, let's just take a law firm, for instance. If the law firm is in the business of providing legal services, that is what we do day in, day out. If we decide that we need a new website, we are not in the website design business. We're going to go out, we're going to retain or engage a web design company to create that. They are going to quote us a fee for doing that work. It's probably going to be some type of a flat fee or a milestone-based fee. It's not going to be hourly. They manage how the work gets done. They're going to have, and they're marketing those services to other companies, and they're kind of in an independent field and profession. So while the firm might like to have a new website, it is not integral to the work that we are doing. And so that's what I mean when I say integral. And it also illustrates these other factors in terms of having the ability to realize profit and loss, because a web design company is going to set its fee based on how much other work it has. It is going to be able to allocate amongst its own employees how it can profit, what the profit or loss on that job might be, and it sets its fee. So it's not an hourly fee. We're not providing the equipment or the software that is needed for that company to do that work. And it's typically a fixed type of engagement. So that is just a very general example, but I do think it illustrates kind of the control element and how it really plays out with respect to the independent contractor arrangement. So why does this matter? How can misclassification haunt you? For employees, we see this typically come up when things go awry, so to speak. And we see these mainly in the form of wage and hour claims. If an employee is misclassified as an exempt employee when they should have been classified as a non-exempt employee, the issue we have is twofold. One, it's a lengthy statute of limitations. For a willful violation of the FLSA, which is what will be asserted, you're looking at 3 years of potential exposure for back pay, which is going to be unpaid overtime, as well as liquidated damages that are equal to the amount of the back pay, and attorney's fees, which is very often the biggest category of potential liability in these types of wage and hour claims can also very easily be brought on a class-wide basis. So the more people you have that are in a specific position that are misclassified, the bigger the risk of the exposure is, because they can easily be brought as class actions. So keep that in mind in terms of how this operates with employee classification. Independent contractors, again, the wage and hour concerns are still present for them. If they say, I should have been classified as an employee and not as an independent contractor, now all of a sudden minimum wage, overtime exposure, all of the same types of wage and hour claims can be brought. There are also IRS penalties, and more often than not, state unemployment types of administrative complaints that can arise and will subject you to additional penalties there. Criminal penalties are possible. They are exceedingly rare, but it is something that is a consistent enforcement priority for from an IRS and from a state unemployment standpoint. So how do we avoid all of this? You want to be thoughtfully classifying all of your employees and contractors. And when in doubt, again, classify someone as a non-exempt employee. That would be the default rule. And we'll talk about the next pitfall involving some non-exempt employees in our next slide. But that is the default rule. And if you're trying to establish that someone is either exempt or is not even an employee and is an independent contractor, remember that the burden is on the company to do that and to do it properly. And so closely evaluating that is smart. One other note I'll make on the independent contractors is I see oftentimes that employers tend to think if it's a short-term engagement, that means that suddenly we can classify someone as an independent contractor as opposed to an employee. And really the length of the engagement is just one of those factors, but I still would say that if the work they're doing is integral to your business, that would override the temporary nature of the work that's being performed. So just keep that in mind, because I hear that quite a bit in terms of, well, it's just going to be on a short-term basis, or it's as needed. And sometimes if all those other factors are present, that can suggest a bona fide independent contractor relationship. But more often than not, for instance, if someone's backfilling for a full-time employee that's out on leave or something, if you look at those factors, if they're doing what that other person was doing, there's no reason to classify them as an independent contractor just because the permanent employee is out on leave. It should be classified as a temporary employment for a specific duration, and make that clear. So we'll move forward here to our second pitfall, which is closely related, wage and hour violations. So again, here we're talking primarily about employees, and really what I'm focusing on in this one is non-exempt employees. And what do we see the common pitfalls are with non-exempt employees? Off the clock work continues to be a huge concern. So and really your best defense to this one is going to be your training, making sure that your employees receive training on your policies, but also monitoring them. So if you know that you have a non-exempt employee who is constantly responding to emails on the weekends, and responding to emails after hours, we all have our emails on our phones now, and even that can be problematic if those hours are not being recorded and paid. And so it's good to have policies that say you need approval to work overtime, but we have to remember that if the employee does not get approval, overtime hours still need to be paid. So we cannot deny paying overtime hours simply because an employee did not request advance permission prior to working them. It's really more of a disciplinary issue at that point. So keep that in mind. Unpaid training or travel. Dealing with travel for non-exempt employees can be quite complex. It really depends on the method of travel, the hours of travel, as to whether or not travel time is compensable. So if you have non-exempt employees who are doing a lot of business travel, particularly overnight travel, definitely I think it's a good idea to make sure that you have had someone review your policies so that you can ensure that you're compliant on that, because there are some really tricky rules when we talk about that. Any kind of training, if it's a benefit to the employer, then it should be paid and it is compensable. So just remember that as well. Automatic deductions, and unpaid breaks. Generally speaking, unless you're in a manufacturing environment, when you know that the break times are at certain times and we're going to be able to prove that, automatic deductions for meal periods are not something that I like, because I think it's very easy for someone to be able to argue that they did not get their meal break or they weren't allowed to take their meal break. And so if you're going to have a policy like that, you also need to have very good policies for how to report missed breaks and make sure that your managers, again, are tracking that and enforcing it, and are making sure that if meal breaks are missed, that they are accurately being caught and employees are being compensated if they work through a meal period. Again, for most of our clients now have, despite all of my advice and protests here, have remote employees in very very employee friendly states: California, New York. The wage and hour laws and the meal and rest break laws in those states are very complex, and you definitely need to make sure that if you have a remote employee that's working in those states, that you have worked with counsel to make sure that you're compliant on how to make sure that that you are correctly tracking meal and rest break periods and paying overtime pursuant to the laws there. One of the easiest things to do in this area that I see doesn't happen quite a lot: require your employees to acknowledge receipt of your wage and hour policies. That's rule number one. Have them sign off. Have them sign off on, we don't allow people to work off the clock. If you work off the clock, here's how you report it to us so that we can make sure you're properly compensated. Secondly, having them verify the accuracy of their time records. With all of the technology that we are using now, where employees can log in and out from their apps, having them click an acknowledgement box or sign off on the accuracy of their time records can be make or break in some of these wage and hour cases, where someone tries to turn around and say, well, those weren't correct, I didn't get paid appropriately, I was doing all this off the clock work. If we have, bi-weekly timesheets where the employee has said, I verify that these are true and accurate, then that can really, really help when it comes to defending these types of claims. So some more prevention tips. I think I've hit a lot of these. Again, training the managers not to allow off the clock work and to be monitoring it. It's not enough to have the policy. Need to make sure that the managers are enforcing it. Requiring the accurate timekeeping, And then audit your exempt positions annually, or at least, every couple years. Roles tend to evolve, and making sure that we feel as though the position still, this goes back to also kind of holding you accountable to your job descriptions, which is always a good compliance policy, that we still feel like those positions meet the criteria needed to qualify for an exemption if they're exempt roles. So I think I'm going to flip it over to Maja now to talk about our next pitfall.
Thanks, Emily. Hi, everyone. My name is Maja Hartzell. Like Emily said, I'm an associate here in the Nashville office in the Labor and Employment Group at Burr. I am very excited to be here this morning to start off Halloween talking about these compliance issues that can creep up on the employers. So let's start with one of the most classic horror stories that Emily and I encounter often, the botched investigation. An inadequate investigation is the beginning of a horror movie that we see far too often, not because the HR intended to ignore a complaint, but often because the process just broke down somewhere. As you all know, I'm sure, under Title VII and the EEOC's enforcement guidance, once an employer knows or should know that harassment may be occurring, it has a legal duty to act promptly and effectively. So really, the real fright isn't the complaint itself, but it's the investigation that never happened or one that was done halfway. So let's talk about a few common causes of these investigative nightmares. First, there's the anonymous or confidential complaint. HR gets a tip, but decides not to act because the employee asked to remain anonymous, and HR just assumes that their hands are tied. The reality is, though, that the law does not really allow you to ignore a credible report of harassment, discrimination, or retaliation just because the employee wished to remain anonymous. So you can and you should act. You can investigate discreetly, protect confidentiality to the extent possible, and address the issue, but doing nothing creates bigger exposure down the road. Second, we have going through the motions. This happens when an investigation is treated like a checklist. Talk to the complainant, talk to the accused, call it a day. And listen, Emily and I like checklists, but you have to be able to adapt and be prepared to adapt. So, credible investigation gathers facts, corroborates timelines, follows up where appropriate, reviews emails, text messages, documentation. Skipping all that work can signal bias or laziness, and neither one looks good in front of a jury. Then we have conflict of interest, having a manager investigate their own subordinate or someone in accused reporting chain. This can undermine credibility. It doesn't have to, but it can. It's always safer to assign an HR representative or even an external investigator, a neutral third party, like an attorney, because a biased investigation can be worse than no investigation sometimes. Fourth, we have the casual approach. I talk to them, it's handled, there are no notes, no summary, no findings. In mine and Emily's world, if there's no record, no documentation, it's like it never happened. So, agencies and the juries expect professional documentation. Without it, even if you put in the work, you have nothing to show for it. And finally, being late to the party, waiting weeks before starting the investigation because you're short-staffed or, it's a busy season and you keep putting it off. Courts and agencies have little patience for that. Promptness is the first thing that they will look at. So even a few weeks delay can suggest indifference, which is like what you're trying to avoid. So all of these or any of these factors can make the company look indifferent or retaliatory. The takeaway is like HR does not need to solve the mystery like a detective, but it needs to show that it acted promptly, reasonably, in good faith, and consistently. And a credible investigation is what going to separate a defensible case from a six-figure settlement. So just remember that juries forgive mistakes, but they don't forget indifference. Let's flip to the next slide. So let's talk about some tips on how to keep your investigation from turning into that horror show. I mean, I already covered a lot of it, but first, take every complaint seriously, even the casual or off the record ones. Keep in mind that a supervisor's knowledge is the company's knowledge. So training supervisors on the proper way to handle complaints, however minor, is crucial. And I think the common theme of this presentation is going to be, training, documentation. Those are like the key things that you need to keep in mind to avoid all these horror shows. Start promptly. Even a preliminary conversation or an email just outlining next steps and what to expect shows diligence, shows that you care. Investigate thoroughly and neutrally. That means, interviewing all relevant parties, reviewing all evidence, giving both sides a chance to be heard. Document your process. Just document. Who you speak to, when, what did you learn? What did you ask? What did you do with the information? This is your strongest defense in harassment cases. This is the first thing that the agencies ask for, the plaintiffs ask for, we ask for, the documentation. It's not everything, but it is very important. And then once the investigation is complete, take appropriate action based on findings. Not every case warrants discipline, but every case warrants some sort of a response, whether it's a follow-up training or just a cautionary conversation. Communicate the outcome. This step is often skipped. And what we see, it's underrated how important it is to tell the employee who complained that the matter was reviewed, investigated, and appropriate action was taken. You don't have to go into details or even the reasoning behind what action was taken, but if you communicate the outcome, it shows that you took the issue seriously, and it shows that you care. So again, silence looks like indifference, and that breeds that mistrust. And finally, follow up. Check back after a few weeks to ensure that there was no reoccurrence of the complaintive behavior or any new behavior that's problematic, or that the employee doesn't feel like he or she is being retaliated against in any way. So this small step, which also is often overlooked, can prevent a lawsuit down the road. So to sum up, investigate promptly, document everything, be neutral, keep the door open for follow-up, and everything kind of builds from that.
One thing I'll add about following up is communicate that little touch point in writing too, because oftentimes we hear, I complained, nothing was done, it continued. And most of the time, I think HR does a great job of doing all of this. It's that email to the employee after the fact. Hey, thanks for your time today. As discussed, things have improved with, supervisor, or just kind of documenting back to them in writing that when you did touch base, they told you things were going better. And then you can say, as you know, my door is always open. If something happens, having something like that, it can take, a minute to send it, but it can really, really help in the event of a later on retaliation claim or some type of complaint from the employee asserting that we didn't do what we should have done.
Yeah, that's a really good point. Okay, now let's move on to my personal favorite, the zombie policies. And I say that because I review a lot of handbooks and policies, so I'm very familiar with how these things can creep up on you. So, a zombie policy looks fine on paper. It's in your handbook, it's in your onboarding materials, but it really died years ago. The laws changed, practices evolved, but the policies just kept walking the halls. Nobody noticed. Everybody assumed that somebody else updated it. Emily always says that assumption is like the worst enemy. Legal trouble often begins not with bad intentions, but with assumptions. So when a policy hasn't been touched in years, it's not just stale, but it starts to undercut your credibility down the road. And plaintiffs' attorneys love that. So the root of the problem is either you don't have one, an employee handbook is silent on key issues like social media use, attendance, accommodation process, complaint reporting. That opens the door to miscommunications, and then that the legal exposure follows. So when employees don't know the rules, they create their own, and enforcement becomes inconsistent. And that inconsistency usually leads to more serious problems. So for example, take attendance. If one manager enforces punctuality strictly and another looks another way, that inconsistency alone can support a discrimination or retaliation claim. A clear policy sets a standard for fairness if it's followed. Missing policies can also send a cultural message. I mean, they suggest that the company doesn't take certain issues seriously, like anti-harassment, pregnancy, disability accommodations, data privacy. On the flip side of this, however, the solution isn't exactly a massive manual that nobody reads, that is or is not updated. A handbook should be a living, customized document that matches your organization's size, industry, jurisdictions. So, when your policies are clear, current, and communicated, they stop being liability and start being a best defense, which leads us to the next slide. So what happens when, those zombie policies stay buried in your shared drive? They can rise up and attack your defenses down the road. When a policy is outdated, it doesn't just look sloppy, it actively undermines your ability to defend legitimate employment actions. For instance, say you disciplined an employee for absenteeism under an attendance policy that doesn't account for new state sick leave laws. That policy might directly conflict with a protected right, turning what you thought was a routine write-up into a retaliation claim. We often have employers come to us and say, well, our PTO policy is robust and generous enough that it accounts for the state's sick leave entitlements. And sure, like in terms of accrual and the allowance of how much PTO the employees get, like that satisfies the state's sick leave laws. But they also have these other built-in little protections that are often overlooked. For example, a lot of PTO policies have requirements. They have to request time in advance. And if you don't do, you might be subject to discipline. But a lot of these state sick leave laws say that if the employee needs to take time under one of those protected categories, they can't be disciplined for it. So if the policy is not clear and if the supervisors and managers are not trained, that might lead to an issue down the road.
What can I interject with one common policy, Maya? I wonder if you've seen this. Sometimes we see policies that also they just shouldn't, they're not helping, they're hurting, right?
Mm-hmm.
So example being job posting, internal promotions.
Right.
How have you seen those be problematic before?
Well, I think if they're too detailed and they don't really need to be in the handbook, they tie the company to what the handbook says, and the employee can come back and say, this is what the handbook said, but this is not how it was applied. Or, the employer will treat two employees in a different way, but the policy, says something different, and that leads to a discrimination claim down the road. So unless the policy really needs to be in the handbook, we typically advise against being too detailed. Another policy I was gonna mention is drug testing. You know, a lot of companies haven't updated their drug testing policies since the recreational marijuana has been legalized in several states. So a positive test result might not justify termination under current law in some states. So if there's no like distinctions of evidence of on-duty impairment and just a positive drug test, that can lead to issues as well. Another one, harassment policies. If your policy lacks the modern elements like reporting options, some states require you to put the contact information for the state agencies in the policy. The New York policy requires you to have a special form of a complaint that's attached to the handbook. Like, there are little things that should be followed, and sometimes, if the handbook or the policy hasn't been updated in a while, they're not up to date. And then the last one I wanted to mention is the use it or lose it policies, PTO policies, that, the businesses may find themselves on the wrong side of the law if they operate in multiple states, because a lot of states don't allow use it or lose it policy in terms of PTO. So those are just the things that we see here and there that are worth thinking about.
Well, and I think there are also things that, again, whereas pre-COVID, if you were a Tennessee employer, you probably felt pretty good with your handbook. But if now you have allowed people to move across state lines or you've hired remote employees, that raises new implications for your handbook, right?
Right, exactly. So how do you slay these policy zombies for good before they rise again? Again, I mean, we already talked about this. Make sure that your handbook fits your organization. A 5-person startup and a 2,000 employee national company shouldn't be using the same template. Overly broad policies create obligations that you can't meet, and overly vague ones leave too much discretion. There's a distinction between those two, a fine line that you have to walk. Commit to reviewing your policies at least annually. You'd be surprised how many laws can accumulate, how many changes in laws can accumulate in 1 year. And even if the federal law hasn't changed, there's a good chance that state or local updates did. When you roll out your updates, make sure to train your supervisors and managers. Supervisors are the first line of compliance. They're the ones that the employees go to first. If they don't understand or follow the policy, the update doesn't really, exist in practice. Conduct multi-state reviews. Like we talked about, if you operate in multiple jurisdictions, you need to know where policies diverge. It's okay to have state supplements. It's not okay to have a one-size-fits-all policy that can potentially violate some other state's laws. And schedule legal reviews roughly every 2 years. Employment law moves fast, and having counsel audit your handbook ensures that it's not only compliant, but also consistent with your actual practices. So to sum up, regular policy maintenance isn't just busy work. It's the shield against your employment claims. So, keep it clean, current, and consistent. And then this goes in line with everything I just talked about too. The next classic horror story, the skeleton crew, which goes hand in hand with everything we have talked and we're going to talk about. Everything is about documentation or the lack of it. The documentation is the backbone of your defense. When an employee claims discrimination or retaliation, this is your primary evidence. If it's thin or inconsistent, your defense might collapse. Documentation establishes reason and timing. It shows that performance issues existed before the employee engaged in a protected activity, or that the attendance violations occur consistently across employees. Without that contemporaneous documentation, you're stuck arguing credibility, and it's your word versus theirs. And judges and juries and agencies, they rely heavily on these contemporaneous records. The things that are created when the decisions are made. Without these, they have to rely on memory, and memories are subjective. So for instance, weak or inconsistent documentation can destroy your retaliation defense, like I just said. Imagine an employee files a safety complaint and then gets a poor evaluation a month later. If there was no clear prior record of the performance issues, the timing looks retaliatory, even if it wasn't. And that's when the jury starts thinking, well, maybe this was retaliation. And I'm not saying the jury's not going to think that even if you have really good documentation, but it helps. And Emily and I see this all the time. A manager says that performance was poor, but the employee's last evaluation says meets expectations. Or HR can't find any written warnings for the employee, even though supervisor insists that they had lots of conversations about their performance. These are the issues that we deal with every day, and could be so easily, fixed if people just kept those up-to-date notes. Another red flag: vague or judgmental language in the evaluations or disciplinary notes. Poor attitude sounds subjective, but if you say the employee missed 2 calls and failed to submit project summary by deadline, that's factual, and specificity shows fairness, whereas vagueness might show bias. The inconsistent enforcement, that's its own form of weakness. If one employee is written up for tardiness and another one isn't, these small disparities can create risk down the road. And then one thing I wanted to note, remember that in today's digital world, your documentation isn't just paper, it's emails, Teams chats, Slack messages, text messages. Try to make sure, to the extent possible, that all these records tell the same story. If they don't, that inconsistency will be pointed out later in litigation. So in other words, documentation isn't just paperwork, it's your communication tool. It shows employees what's expected, shows the courts that you acted reasonably and consistently. So think of it as a skeleton of your defense. Without structure, everything else will collapse. So let's move to the next slide. Again, we basically covered this. How do you give that skeleton some muscle? Start with the basics, make every write-up factual, dated, and specific. Require acknowledgement. Even if the employee refuses to sign, document that they were offered that opportunity. Follow up verbal warnings with quick confirmation emails. Short 2-sentence message saying, hey, just confirming our discussion today regarding your attendance and expectations is really important for us in litigation. Train managers to write in plain factual language, avoid emotion, avoid exaggeration, hold managers accountable for timely and honest performance reviews.
Again, I'm going to hit the performance evaluations a little hard, because it really, if you're not doing it, it creates this opportunity to, at least on an annual basis, do what Maya's been discussing here with this documentation, because we realize everyone has a business to run. Your managers, your supervisors, they also have things that they need to be doing, and this can turn into a full-time job just when done appropriately. But if you can force them to sit down once a year and do a candid performance evaluation, that's key, because the only thing worse than having no documentation at all is when we get a new case in and we ask for the personnel file, and we get on the phone with HR and the manager and they say this is the worst employee ever, and we think, yay, it's going to be a slam dunk, and we get the personnel file and we open it up and it's 10 years of glowing performance evaluations from said supervisor who now has told us this person's the worst employee they've ever had. So again, I think a lot of the documentation, not only is it helpful in the event of litigation, but it also clearly outlines the expectations for the employee. And at the end of the day, I believe, some people, they're going to file suit no matter what we do, but the vast majority of people want to believe that they've been treated fairly. And so when it comes time to have a termination decision or something, a difficult discussion with an employee, they should know and expect that that's what's coming. And the reason they do that and the reason they have that understanding is because we have done our job in terms of documenting leading up to a termination decision. And so they should know. And I do think that that mitigates claims when people feel as though they've been treated fairly. If I had, instead, what I feel like a lot of the times in the more problematic cases we have are the EEOC charge that says I was a great employee and I was never told that anything was wrong about my performance. And again, if this isn't in writing, then it never happened. So, this is a soapbox that I could talk about for all day long, if we needed to, because it really does come back to just the simplest things that can have the biggest impact in terms of your, HR compliance strategies.
Yeah.
All right, we're going to talk a little bit about leave. And again, this is the second subject that I could probably spend all day on, because I know that a lot of you are just, frankly, beating your heads against the walls, dealing with all of the accommodation requests and the remote work requests. And this is just, you're not alone. I want to say that. Everyone is struggling with this. In terms of the reasons for it, I could hypothesize about it. But I think some of this has to do with the fact that just as a society, it's becoming more politically correct to kind of talk about mental health issues. So I'm seeing a lot of this come up with mental health. But I also think that there's just there's some employees who legitimately need support, and there's some of them who are certainly trying to game the system a little bit in this area. So and I think, as HR professionals, you guys kind of, it when you see it. And it still can be challenging to try to help your business folks understand, why we can't fire this person, why they've been out for so long, and yet we're still having to go back and look at extending additional leave. So we know that this is a pressure point for you, but we're all doing the best we can to kind of navigate it. The one thing I will say kind of overall, in the pitfall that we can get into with leave generally, is not understanding the overlapping nature of the laws. And then it goes hand in hand also with not being on top of requiring the appropriate documentation to both support a request for leave, and then also evaluate coming back from leave, and getting tripped up, I think, in the web of different entitlements that an employee may have, right? So what do I mean by that? I mean, obviously we have overlapping laws, policies, and then there's also insurance type of buckets. And I think that what I see most often is employers get kind of tripped up at one stage in this. So something starts as a workers' comp claim, then it turns into an FMLA claim, then we have an ADA claim. And so, all of these, we have to remember that while each has different triggers, the employee is going to be, the laws overlap, and the employee needs to be given the benefit of all of them. And so it may be that there are multiple laws at play. For instance, a workers' comp injury, right? If someone's on workers' comp that is a insurance benefit that is provided through your workers' comp insurance carrier, where they are getting income replacement in the event that they cannot work. They do not get leave, though, unless you as the employer approve that leave. And when you approve that leave, it should be for a specific amount of time. Now, in the workers' comp context, there's an incentive from the carrier and from you to get this person back to work, because if we get them back to work, then we're not paying the income replacement. But we do need to understand that documenting their absence is, unless you have a specific policy that is a workers' comp leave policy, is going to fall under your short-term medical leave of absence policy in the same way. And so this is very similar to STD and LTD. I hear a lot of the time, well, this employee is receiving STD. STD is an insurance benefit that provides income replacement when someone cannot work. It's not a leave of absence. You as the employer are the one who has the right to grant leaves of absence. And we need to grant leaves of absence or consider granting them. One, if they're required by law. So FMLA, that's really clear. Anyone who's eligible for FMLA is going to have a right to take up to 12 weeks of job protected leave in any given year. Under the ADA, someone who has a qualifying disability, which if they're receiving STD benefits, they probably would also meet the definition of having a disability. Then we need to consider, do they, even if they're not eligible for FMLA leave, do they qualify for a short-term leave of absence? And most of the time, the answer to that should be yes. The question, if they are able to provide appropriate medical documentation to support that, the question of how much leave they're entitled to is a much more complicated question. And that's going to depend on what the doctor is saying, what the essential job functions are, and also what the law, or I'm sorry, rather what the employer is saying, what the physician is saying about when that employee can return to work. So where are the pitfalls here? FMLA exhaustion as being the end of the leave entitlement. That's almost always going to be set you up for a pretty clear ADA violation, because we know the EEOC has said for over a decade now that you have to consider granting an additional period of leave after FMLA exhaustion as a reasonable accommodation under the ADA. And normally I will recommend that some period of leave be provided. What we don't want to do, and what I see employers trip up on most of the time, is we are not clearly documenting when someone is out, what it's for, how long it's for, what the expectation is if they need an extension of time. And so what we have is people get stuck in limbo, where they've been out, they're on STD, but we have no documentation that went to the employee saying how much leave we have approved as the employer, when we're expecting them back, and what they need to do if they need to request an extension of time. And what this results in is that we end up having to grant a lot more leave than we might otherwise need to, because we have to go back and do the documentation once the person has been out on leave for a period of time. So keep in mind, that again, all of these entitlements can apply at once. But really having a good understanding of the differences in all of these, and then making sure we're documenting and understanding the distinction between someone who might be receiving STD benefits and who is on an ADA leave of absence, and to avoid a situation where we inadvertently grant indefinite leave. Because just because someone is receiving STD benefits does not mean that you need to necessarily continue to employ them. If it's indefinite, if they're in a car accident and they're paralyzed and they're never coming back to work, we would have the right at that point, after exhaustion of FMLA, to usually to terminate that employee's employment. As harsh as that sounds, but it starts with an understanding of the differences between these types of laws. So make sure you're communicating early Again, we have templates for this, and make sure that you're not just relying on the FMLA paperwork. I like to send a separate letter that makes it really clear to the employee. We've approved this type of leave. It starts on this date. It ends on that date. If you need an extension, you need to contact us by this date, and here's what we need. Otherwise, we are expecting you back at work on X date, so that you have regular checkpoints with these employees who are on these longer term leave of absences, to where you can request updated paperwork and go from there. So I think we are about at time. I'm going to hit retaliation really quick, but I think Maya's done a good job of teeing that up, because it really goes hand in hand with documentation. The best defense to a retaliation claim is having good documentation that of ongoing performance issues that predate the alleged protected activity. So, it goes back to, if you're doing those performance evaluations, if you're documenting performance concerns when they happen, if you're not doing these things, I'm telling you, employees have a sixth sense about sensing when they're about at the end of the rope and are about to be terminated. And they find ways to have, harassment claims, worker comp claims. They find ways to engage in protected activity. And so what that does is kind of make it very challenging to proceed with a termination decision without risking inviting a retaliation claim. So keep that in mind. These are probably, aside from the ADA claims, retaliation claims are I think the most claims that we're seeing right now. And I hope that everyone has a safe and happy Halloween. And if you need help with any employment issues, feel free to reach out to Maya or me.
Thank you, everyone.